Good afternoon, everyone. My name is Mike Callahan. I'm a professor of the practice at Stanford and a director of the Rock Center for Corporate Governance. And I'd like to welcome you today to our program on the new antitrust agenda in DC. And before we get started with our panelists, let me cover a few logistics items. First, this program is being recorded, as you were just notified by the Zoom app. After I do brief introductions of our speakers, we will cover a number of topics as a panel until about 45 minutes past the hour, and then we'd like to welcome and open it up to audience questions. Please use the Q&A tab at the bottom of your Zoom screen, which I'm sure you're all familiar with by now, and I'll moderate and ask the questions from our end, and we really do look forward to having the engagement with the audience and appreciate all of you taking the time to be with us today and hear from the experts that we're delighted to have join us for the program today. So let's get started. You all have long form bios available on our website, and the bios for these panelists could be quite long given their accomplishments. So I'll be brief and then we'll get in to the discussion. First, I'd like to introduce Commissioner Noah Phillips. He has been a commissioner on the Federal Trade Commission since May 2018. And prior to the FTC, has years of senior policy and legal experience in the United States Senate and private law practice. He is also one of our alums, so I'd like to welcome Noah Phillips virtually back to the Law School Commissioner. Thanks for joining us. And I'd like to
having me.
Yep, sure. I saw you come off mute there. And also, for Commissioner Phillips, I want to make it clear that any remarks he makes in this program is on behalf of himself, does not represent the views of the Federal Trade Commission or of any other commissioner. And I want to thank you, Noah, for taking the time to be with us. Jamillia Ferris is a partner at Wilson Sonsini in Washington, D.C., where she focuses on antitrust and has deep experience on the regulatory side at both the Federal Communications Commission and the Department of Justice, where she served as Chief of Staff and Counsel to the Assistant Attorney General of the Antitrust Division. Thank you, Jamillia, for being here. Sonja Perkins is the Managing Director of the Perkins Fund, has been investing in people and companies that matter for over 30 years in Silicon Valley. Sonja began her career at TA Associates. She spent time at Symantec and then spent 22 years at Menlo Ventures. Sonja is also the founder of Broadway Angels, which is an investment group made up of world-class investors and business executives who also all happen to be women. And she's also the founder of Project Glimmer, which is a national nonprofit that inspires every girl to envision and realize her empowered future. Sonja, great to see you. Thanks for joining us today.
Thanks for having me.
And our final panelist is Doug Melamed, who is professor of the practice of law at Stanford Law School. Immediately prior to joining Stanford, Doug was senior vice president and general counsel at Intel Corporation. Prior to Intel, Doug was a leading practitioner in antitrust and competition law with WilmerHale, and was also a leader in the Department of Justice, serving as acting assistant attorney general in charge of the Antitrust Division from 1996 to 2001. Thanks, Doug, for being a part of the program.
Thank you. Hi.
So I'd like to jump in first and start with the big picture. So starting perhaps a few years ago, there have been increasing calls from Washington from a number of quarters to do something about big tech and its concerns all the way from data privacy to election disinformation to Section 230, which we could do a whole nother 3 hours on, and incitement to violence most recently are all in the mix. Perceived market concentration among the big platforms with Apple and Google and Facebook, Amazon, Microsoft, that's drawn even more attention. In the new Biden administration, there's some appointments that have been talked about to your commission, Commissioner Phillips, as well as academics who may join the White House staff. And it all signals there's some changes afoot for tech as it relates to Washington. And so from a big picture perspective, Commissioner Phillips, how do you break down these concerns? Where do they start? And how much of this is really about antitrust? And what's your perspective on the whole area?
So taking the liberty, Mike, well, first of all, let me thank you and thanks to the Rock Center and Stanford Law for having me. It is an honor to be here with this great group of people. And it's always a pleasure to be back, even if virtually at Stanford, a place dear to my heart. I think we are at a really interesting moment. In particular, with regards to big tech, you just rattled off a litany of different issues. To many, they are problems. To others, less so. To most, it probably depends on which you're talking about. And antitrust is being brought to the public by a variety of stakeholders as one of, if not the solution to all of them. I will tell you, I was in a hearing on antitrust reform in the House of Representatives 2 weeks ago, and it was political speech. And how can antitrust solve our political speech problems? My view is that some of these things are real issues. Some of these things are more perceived issues. Some of these things impact different people in different ways. Privacy is a real issue. I think we need to tackle it. One of the things that makes it difficult is different people experience different practices in different ways. But what you hear consistently in Washington at this point is that antitrust is the appropriate tool, even a weapon, to use to arrive at the solutions. So I have heard, for instance, in the last couple weeks, senior politicians in Washington saying, I don't like what you're saying about me, or I don't like the political position you're taking on a matter, let's say in a state, and we're going to use antitrust because that's something you fear. And I am concerned, right, that this is the kind of rhetoric we're hearing. I'm concerned both because I don't think that weaponizing antitrust as a sort of general government cudgel is the right way to approach it. But I'm also concerned because it's not clear to me that antitrust is designed to or would be efficacious at solving many of these problems. So the last time I was at the Rock Center, I touted privacy as an example, right? It may be that there are market power problems, that lead into a lack of privacy, but a lot of this also isn't market driven. And relying on antitrust to do the work there is not going to be good for antitrust, but it's also not going to be good for privacy. And I think however we're going in Washington, as we look to orient policy, we should ask questions about antitrust and how it's doing and whether it's dealing with all the real competition issues in big tech, nascent competition, two-sided markets, network effects, and so forth. But I think we do need to be sober and rational in recognizing, first of all, what antitrust law can do, and second of all, what the costs are of using antitrust broadly as this cudgel to get at everything.
Thank you for that. Doug, I'd like to get your perspective on this. I mean, you've had the benefit of leading the DOJ's antitrust division, as well as sort of being around the space and in Silicon Valley for years. How do you see this, and where do you think this is headed?
Well, I agree with everything that Commissioner Phillips said. Let me add a couple of thoughts. We live in a time of populism from the left, obviously, the Elizabeth Warrens and Bernie Sanders and the New Brandeis folks in the competition field, who are, I think, the most outspoken in general in trying to, in effect, capture antitrust for their populist purposes, which are mostly focused on equality kinds of issues. And of course, now the populists on the right that are upset with what they regard as censorship and other indignities to their political views. And I think the populists have made the largest amount of noise, and they overlook the fact deliberately, I believe, as a political strategy, that antitrust for at least the last 40 years has been exclusively focused on economic welfare. And all antitrust violations, ultimately, conceptually, are very simple. There are two things: anti-competitive conduct, which means conduct that does not enhance economic welfare, that has the effect of increasing market power, which reduces economic welfare going forward. That's it. And most of these concerns, privacy and censorship and disinformation and social disintermediation, have nothing to do really with antitrust law. And it would be, I think, a shame to deputize antitrust or pervert it by legislation or otherwise to try to achieve those non-economic objectives. Having said that, there is a legitimate and quite separate, I think, push for incrementally more aggressive antitrust enforcement in general, because of a view shared by many, not all, that antitrust enforcement has on the whole been too lax and the courts too conservative, and that in particular, the tech platforms bring that into sharp focus because they are perceived as being not only big and powerful, but as being unstoppable, having kind of boundless scale and scope economies and network efficiencies. So I think antitrust enforcement is probably going to be a little more aggressive in the future than it has been in the past. without legislation, even if the populists control the agencies, there's not much they can do about it because the courts, I think, won't be receptive to the more radical proposals. The big issues, I think, are will something come from Congress? And absent that, what will happen to the Federal Trade Commission with respect to the push for rulemaking? There are probably 2 votes on the commission, if you assume Lena Khan will be confirmed to replace Commissioner Chopra, in favor of an aggressive use of the rulemaking power. There's a vacancy yet not without a nominee yet. That's a potential kind of watch this spot area, I think.
Thank you, Doug. Sonja, I want to get your perspective here. So you've been working with startups, advising, investing for decades. What feels different, if anything, to you now? And are regulatory concerns something that you're thinking about more, spending more time on, and others like you are investing more intellectual capital in?
Yeah, well, a lot feels different. So when I started in the venture industry, the PC was just coming as a business tool, and then we grew into the internet, and everything was new, and everything was increasing productivity, and technology was loved, right? We all loved being more efficient at work. And when the iPhone came out, and then these big platform companies came, like Google and Facebook, everything changed, right? All of a sudden, all the startups were reliant on everything that the FANG companies had to do, right? And then they had so much power, and people started getting very angry about privacy and about data and misinformation and all these problems and all these unintended consequences. And hopefully there were unintended consequences that these big companies provide, and they became hated, right? And so tech is no longer loved. It's got a big arrow on its back, and people are out to get tech, and there's, I think, a lot of legitimate reasons to do that. So in terms of antitrust regulation, I don't think about that too often, because a lot of the companies that I'm funding are far away from being monopolies or, having those kinds of advantages that some of the big FANG companies have. But I do think a lot about regulation, not just as a venture capitalist, but as a person. Like when we had issues like what happened on January 6th, I mean, that affects our country, it affects our democracy, it affects, everything. And so I think regulation is important. And I think it's very important because, all of these companies, the FANG companies, every single one of my startups is reliant on them. And I have a company that was having a great success getting customers through Facebook advertising. And then they changed their algorithm, and then they lost, any advantage that they had through that. And there's these things with searching and advertising and algorithms that are kind of life and death for a lot of startups, and they really are reliant. So I think a lot about it, and I'm hopeful that there will be some smart regulation that levels the playing field.
That's a great point, and that's something I want to spend more time on, is the impacts on smaller companies and innovation. But so there's a few different big things that have happened recently, and I want to start with Facebook, and then I want to move to what's happening on the Hill, Jamillia, to talk to you about that, and then maybe spend some time on Google. But let's start with Facebook. So in December 2020, the FTC brings a lawsuit against Facebook, alleging illegally maintaining a personal social networking monopoly, specifically calls out Instagram and WhatsApp as acquisitions that were done to either eliminate threats to that monopoly. And Commissioner Phillips, I realize you can't comment on specific actions, but you were one of 2 commissioners that voted against bringing that lawsuit. Could you explain your thinking a little bit on this issue in general?
Sure. And I mentioned earlier this hearing that I did a couple of weeks ago, where the House Antitrust Subcommittee Chairman Cicilline asked me about that vote, so I can certainly talk about what I had to testify to. And a big point that I hit is that the gravamen of the complaint is these 2 acquisitions, and the 2 acquisitions took place in one case, in both cases, the better part of a decade ago. In one case, very nearly a decade ago, and they were reviewed not just by the Federal Trade Commission, but by other agencies. They were allowed to proceed, and then, consistent with those facts, right, the company made investments in those companies. And I do think this case, which is distinct from a lot of other cases that I think are really on the edge of antitrust with nascent competition, does raise this issue of the integrity of the merger review process. And where you have a set of facts where you don't have a lot of new facts that weren't available to the government ex ante, I think that does color how you have to look at these things. I think it is only fair to do so. So that's sort of bucket number one. I also alluded to some other issues with the case in that testimony. I don't want to speak specifically to the case, but I do want to pick up on a thread that I began teasing earlier on, which is that, you know, there is, as Sonja was noting earlier, there's a lot of concern in particular with, now it's really 4 of the big tech companies. One of the ends, Netflix, seems to have fallen off of the radar, but that was one of our fangs back then. In fact, I think it gave us the word FANG. Now they're subject to lots of competition. And maybe Facebook is the one Washington loves to hate the most, right? I think there are a lot of people who are not totally sold on, at the end of the day, you know, how social media is affecting us, and Facebook is the biggest player in that market, however you define it. But when it comes to law violations, my view of the world, and this is true for privacy, it's true for antitrust, it's true for consumer protection, I'm less concerned with who's in that V in the caption of the case. I am more concerned with the conduct the company is undertaking. And I think every company, from small fraudsters to big companies, they bear the burdens that the law imposes on them. They also benefit from whatever else the law says. And so when we're looking at these cases and we're thinking about, for instance, right, the big daddy of nascent competition antitrust cases, the Microsoft case, not only does it tell us that when we're considering a monopolist, that the government or other plaintiffs get some help on causation, but it tells us we have to consider effects. It looks at the justifications for the conduct, and when they're not ridiculous, it credits them. All of these legal rules bear on every case. And that is sort of the general framework that I try to apply in every case that I see. I want to end with the following, because I think it does read on something I've said, and to some extent it bears thematically on the facts at issue in Facebook. I do think how, in particular, monopolists, but in general, when companies are acquiring nascent competitors, I do think there is a correction that antitrust enforcers are and should be making in terms of where we're willing to run the risks. I think we should be a little bit more skeptical of claims that the merger is required to effectuate competition, and they'll give a little more credence to the risks that may arise. And I think in cases in consumer products, this is Harry's and Schick, this is Billy and P&G. I don't know why it's always razors. This is the Illumina horizontal case a year and a half ago involving PacBio. And we just sued Illumina again on a vertical transaction. So we are looking at these cases. And I think that is a big change that is already ongoing in enforcement.
Appreciate that perspective. Let's talk a little bit about Capitol Hill, and that came up. I think a couple panelists have mentioned the opportunity of new regulation. And Senator Klobuchar introduced Senate 225, the Competition Antitrust Law Enforcement Act, and it's brought a lot of the concerns that we were just talking about to the forefront in an actually piece of proposed legislation. And some of these proposals seem radical, at least from my perspective, but I'm not an expert. But Jamillia, you are an expert. And so could you break down a little bit of what some of these proposals are and the nature of what they may affect in terms of the ecosystem?
Yeah, so, you know, we talked a little bit about focusing a little bit on the merger space. The Klobuchar bill does, you know, reflect a big change. It certainly lowers the standard for challenging a merger deliberately. So the standard would change. Today, it's a transaction could be potentially unlawful if the effect of which is to substantially lessen competition. Under the bill, the standard would change. It would prohibit transactions if the effect were to create an appreciable risk of materially lessening competition, and materially is defined as more than a de minimis amount. Importantly, along with that standard and that lessening of the standard, it has a presumption of illegality, really, for transactions that fall into a couple of categories. Transactions that are valued at over 5 billion, transactions where the acquirer has 100 billion market cap or value. That captures about 100 companies in the US. If the acquirer has a market share greater than 50% or otherwise is viewed as having market power, if the transaction would lead to market power or material increase the likelihood of coordination among companies, or if it would lead to a significant increase in concentration. And then if any of these presumptions are met, the burden then is on the parties, the merging parties, to establish by a preponderance of an evidence that the transaction won't actually harm competition under the standard. So that really changes the dynamic of merger review at the agencies, where today, of course, the agencies have the burden. So I think that both changes the risk calculus, and I know we're going to talk a little bit about that in terms of whether a deal will be challenged, and if a deal is challenged, whether parties have any hope of getting their deal cleared in the courts. It really is a sea change.
And so on that point of a sea change, you spend your time advising boards of directors on deal risk. How are you shifting what you're talking to now? And we have a big audience of board members that join us.
Yeah.
Like how should they think about this space right now?
Yeah, I mean, well, that's not the law today. So, that's one thing. But if you were to look at, so there's two things to think about. What would the risk look like if this were the law? And then what do you do today in this sort of changed environment where, even as the commissioner said, there's sort of increased scrutiny of transactions. In terms of what it would look like if this law were passed, I mean, certainly it changes really how you negotiate a transaction and where you're going to allocate risk and how you're going to allocate risk. We did this study of sort of 15 years of merger provisions, antitrust risk provisions in merger agreements. And what you find looking across 15 years, if you look at reverse breakup fees, that is fees that are paid by an acquirer if the transaction were to fail for antitrust reasons, the range is about 4.5% to 4.7%. I think you'd see a real change in that. Of course, if you're an acquirer who falls into one of these buckets, certainly the risk is much higher. Will that be enough for a seller to enter a high risk deal, particularly a seller who is going to face a long review? And if it's, kind of a hardware deal or a deal where customers purchase in a long-term timeline, is it really optimal for a seller? Can they really sit there exposed for a long period of time with a high-risk deal? So I think it absolutely will change the risk allocation in merger agreements, as well as the negotiations over those provisions. I mean, I know my M&A colleagues tell me that those, in their deals, those continue to be some of the most hotly contested provisions in a merger agreement. How are you going to allocate risk? So that's only going to increase. But, and today, I think, obviously the standard is what the standard is, but knowing that there is so much scrutiny on transactions, then, and I don't think this is a change as of today. This is a change that we've been seeing coming. It's really important for companies both to understand the risk and be cognizant of what a long review is going to mean, what the likelihood is that a challenge would occur. And that might really look different than it did 2 years ago in terms of the kinds of transactions that are likely to carry high risk. As Sonja said, she's often working with small companies that are not yet at a stage that they're worried about monopolies. But then when they think about exits, Commissioner Phillips flagged 2 deals that the FTC challenged last year in the personal shaving space. You wouldn't think of those, like when you think of what are the FTC's priorities going to be, you wouldn't think, oh, I'm sure they're going to challenge a bunch of deals in personal grooming. But what was interesting about those deals is they were disruptive. These were companies that were disruptive innovators, changing the way a product was being distributed. And, the incumbent traditional provider of personal shaving products tried to acquire them. So companies that might not have been thinking about antitrust when they're thinking about their deals, even outside of the tech space, which we're all talking about today, there's some real risk there that people need to be thinking about.
Thank you for that. Doug, you've been able to advise companies, you've been a GC, you've been an enforcer. Is this a sea change in the Klobuchar bill? And what challenges does it present from an enforcer?
It's a potentially very big change, but let me just, and I really don't disagree with anything Jamillia said, but let me add a couple of thoughts, or a couple of them intended to put this in context. I said in my comments a few minutes ago that there were really two different groups pushing for attack on big companies, if you will. There were the populists, and then there's the I think it was the mainstream antitrust progressives, who want to preserve the conceptual framework and the focus on economic welfare, but think antitrust law should be incrementally made more aggressive. The Klobuchar bill is clearly in the latter camp. This is not a populist bill. This is incremental, maybe some bigger increments, we'll get to in a second, adjustments of existing antitrust law within the existing paradigm. Second point. Many of the provisions, I think, shouldn't be controversial. Increased funding for the antitrust enforcement agencies, whistleblower protection, and so forth. Some won't have much effect, maybe not even worth it, retrospectives and all that. Some are clarifying existing law to overcome the problem of some lower courts and certainly advocates misreading, I think it's fair to say, although others might disagree, some of the rhetoric in some Supreme Court cases in the areas of, for example, does antitrust apply to monopoly power, labor markets, and the like? Does an anti-competitive refusal to deal require a prior course of dealing? Does exclusion require discrimination? The answer to all these questions, I think, is no. This law would codify that. The controversial, there are two basic provisions that really are controversial. One is the merger provision that Jamillia talked about. Completely agree with her description of it. Just want to add a couple thoughts. What informs this, I think, are two things. One, a belief that in general antitrust enforcement in the merger area has not been vigorous enough. And critics point to a number of factors. One, they point to some indications of increased concentration. It's not perfect, although in some industries, certainly in the healthcare industry, hospitals, and air travel and so forth, the evidence seems pretty strong. That's one concern. Another is a number of econometric studies and other kinds of studies that seem to show that anticipated merger efficiencies, in fact, are rarely realized. Now, there's a caveat here. People cite them for that, but what they really show is that cost savings aren't realized. They haven't figured out how to test the proposition that products are made better because of other kinds of synergies or whatever. But that's motivating some of this. And the third thing is the nascent acquisition problem. What do you do about the small company where you can't be, with any confidence, can't say there's going to be harm to competition, but you're worried that if it weren't bought by the big guy, it might become the next big thing and revolutionize the market. That last point, I think, is what drives that language about suggesting a possible harm to competition, kind of lowering the probability a threshold. But I agree that this is far-reaching. Personally, I think some kind of burden shifting, some kind of presumptions might be appropriate if you had more precise and narrower criteria to identify the problematic mergers than simply a big firm. The other area that Jamillia didn't talk about, I'll just comment on very briefly, is suggested provisions regarding exclusionary conduct that would say that any conduct that disadvantages a competitor by a firm that has more than a 50% market share is presumed to be unlawful. I don't like that, frankly. I don't like disadvantage as a competitor because Apple sure disadvantaged Motorola and Nokia when it invented the iPhone, and it's hard for me to imagine now. But of course, the answer there is they didn't have a 50% market share at the time. But you get the point. That encompasses a lot of product improvements and unequivocally efficient conduct. So that's problematic too. But I think it's important to recognize that we're talking about technocrats adjusting at the margin, not a radical populist change to antitrust law.
That's a great perspective. And so let's talk about that, the impacts down the chain of investing in startups, Sonja. So in that startup ecosystem, a lot of these restrictions deal with the exit and preventing or taking a harder look at the big company exit route. As an investor, how important is that big company exit route? And do you think tougher antitrust enforcement or antitrust laws in this area would change your investing strategy or the strategy of others?
Well, I think it's going to take a long time for that to make a difference in terms of when you're going to see changes, because when you invest in a startup, you don't exit at least for 5 to 10 years on average. So it's going to take a long time. But I will say that the vast majority of all venture capital exits are acquisitions. It's very hard to go public because of other regulations, and very few companies go public. And so that's really the source of liquidity for venture capital-backed companies. And so that would really be a problem. Google's acquired hundreds of companies, Microsoft, Apple, they really are big acquirers for companies. And it really concerns me because I think one of America's assets, great assets, competitive assets, when you compare us to other nations, is we have a thriving venture capital industry because it's profitable, and we are able to put very risky dollars into companies to create new technologies and innovations that just isn't in the culture of other countries. And so if we, stop the liquidity path for these early stage companies, the venture capital industry is going to decline. I mean, we all know the cycle of venture capital, where you have high returns, you get more money, you have less returns, then there's no money for the category. And so, if our government decides to make it very hard to have, outstanding exits through acquisition, I think the venture industry really will have a very big problem. So for me, I'm an optimist. I'm still investing. I'm still hoping, crossing my fingers that, my companies will become the next Microsoft or something like that. But I do think for a long-term competitive advantage of our nation, it should be something that we really think seriously about.
So let's go one level deeper on that. So you obviously have the perspective of an investor, but you spend all your time with founders. Do you think more restrictive legal regimes or greater enforcement changes founder activity in any way in terms of impacts on innovation?
Well, it is really interesting because I think there's two kinds of founders. There's the founder that's bred and the founder that's born. And I think the best founders are the ones that are born. And they really are people that cannot sleep at night because they have to solve a real problem and that they have the expertise to do. I think that founder will start companies all day long, and they'll figure out business models that will become profitable and maybe even, go public. I think the student from an unnamed business school who decides instead of working for a company, they want to be a CEO and a founder and go to programs and such to learn how to do that, I think that will go away. I just think that it'll be harder to be a founder, but I still think the best founders will still start companies, always will.
Interesting. Jamillia, Wilson spends a huge amount of time with startups and venture firms. Any changes in terms of how you're thinking about the landscape, or still too early, as Sonja says?
Some of the thinking has evolved, not just because of the legislation, but just kind of a push for more aggressive and antitrust enforcement. I mean, certainly deals that didn't present issues at all because there's either plenty of competition or the companies don't compete at all. Those continue to clear in the first 30 days. So we see deals like that all the time. They just really don't present competition issues. I will say that we get more calls on those deals from the agencies, not that they're opening up investigations in every single one of those deals, but we get a lot of preliminary calls in the first 30 days just to kind of probe a little bit, make sure they're not missing that. I've seen more of that in the last sort of 6 to 9 months that I had seen previously. Almost like it used to feel like if you got a call, there's no sort of light investigation. It really is a serious concern if you hear from them. Now I think there's, it's not statistically significant, but just my practice, I just get more calls on deals. And they ultimately clear in the first 30 days if there's really no competition issue, but they want to probe on those. I think where you're seeing really more of you need to be prepared for the long haul is kind of the close calls on a second request or further investigation. I just think it's much more likely that you're going to get a thorough investigation and a longer investigation, and that investigation is going to be longer, more expensive, more disruptive for the company. And then at the end of that deal, if it's a close call on whether to challenge that deal or not, I think that the goalposts have shifted a bit, and it's more likely that you're going to get a challenge. I mean, that again, I think if you look at the stats, people will say you haven't seen big swings, you haven't seen many more cases, But when you actually look at the cases, it does seem like the agencies are willing to take hard cases, and you're seeing that flesh out, and that's a deal dynamic you need to be prepared for. Totally appreciate what Commissioner Phillips said, that he doesn't care sort of who's on the other side of the V. What matters is the conduct and the competitive dynamics, and I wouldn't disagree with that. I do think, though, there are some companies that get a close look, even on deals that ultimately the agency is able to conclude don't present a problem. But if you're in that space, and it's not just the companies that are top of mind, the FANG companies, it's others as well. As Commissioner Phillips noted, they challenged 2 deals involving Illumina in 2 years.
Mhm.
That's notable.
Got it. So thank you for that. So let's broaden the lens a little bit. We've talked a lot about acquisitions and M&A. Let's talk about other areas of FTC jurisdiction. Obviously extends well beyond just mergers and acquisitions. So Commissioner Phillips, privacy and cybersecurity are really top of mind for boards of directors and their advisors for all the reasons we know about. So what's your advice as an enforcer and as a regulator as you think about those areas for board members and their advisors in the tech or other sectors too?
Sure. Look, I think these are areas where the public awareness, and the public, of course, includes the bar, right, and plaintiffs and so forth, and regulators. The public awareness of some of the risks is growing. And it's growing, roughly speaking, anecdotally supported in proportion to the amount of data that firms are gathering, the kinds of firms that are acquiring data, which is basically everybody, and how they're applying it. So I think the risks are growing. And there's lots of high profile instances. We see this in the news on almost a weekly basis, if not a daily basis, of incidents where real concerns are raised. My view, as a regulator, sometimes you go after companies, sometimes you don't. And, people ought to be familiar with the laws. And as a board member, right, you can kind of leave that to your general counsel. But I do think kicking the tires and asking the questions, hey, is this a risk? What are we doing to address that risk? Can be very helpful. First of all, at least to me as a law enforcer, it's helpful to consumers, right? The more you're thinking about these issues, the less likely you are to confront them after bad things happen. The more likely you are to stop a problem before it manifests. But the second thing, and this goes to liability and it goes to agency practice, is at the end of the day, when we're looking at a fact pattern, right, one of the things we look at is how responsible is the target of the investigation being. So for instance, in data security, we look at the reasonableness of your program. And so people who are taking the time to think through these issues, even if they end up being the victim of an attack, and we're mindful of the fact that sometimes the firm is the victim, taking those steps puts you in a better position, not only to avoid the problem in the first instance, but also to justify your conduct kind of ex post. The other thing I would note, and this is a robust debate that's gone on for years at the commission, the kinds of remedies we are seeking, money, right? Liability of officers and directors, liability of parent companies, what I will, without editorializing, call creativity in some of the equitable provisions, right? The obligations we put on companies. The trend is only to be more aggressive. I'm not going to agree with all of this. That is definitely the trend. And so I do think the risk profile in terms of what the government is presenting also is growing. All of that comes back to, again, with respect to the directors, yes, privacy, data security, also antitrust, important things to have on your radar.
Jamillia, what are you telling your clients?
So cybersecurity is very much top of mind. It's not sort of my area of expertise, but I have colleagues who are advising boards on a regular basis, sort of how to develop both a framework as well as policies and procedures around cybersecurity, including so they have answers to those questions. And they think a lot about liability from a regulator perspective and from a litigation perspective. And I think the question for both cyber issues and privacy is sort of also, where is the board going to make the investment dollars? So to the extent you're going to have teams of people focused on privacy or on cybersecurity, and what is the kind of information that you're holding and what type of investment does it merit having? I think they're spending a lot of time thinking also about the intersection of consumer protection issues and antitrust issues and where they might have risk, not just with federal regulators, but with states attorneys generals who are more focused on these issues as well. And there are certain segments of and certain industries that might be more likely right to capture the attention of state attorneys general, particularly when you think about kind of the morass that is consumer protection and antitrust together and where they might overlap, but that might be kind of a broader area of concern at the state level where the theories may intersect a little bit more. So that's another area that we see boards focused on, depending on the sectors that they're in.
Thank you. So we mentioned Facebook, and obviously that's a big impact on the ecosystem, potential new regulation and legislation. The last piece I want to cover from the big picture is Google, and obviously largest player in search, largest player in online advertising, huge early stage investor, late stage investor. They're all over the ecosystem. So Doug, if you could talk to us a little bit about what does that case mean from a practical sense, from your point of view, both the states and DOJ, and you can take them together if you like, however you want to break it down. And then Sonja, what does that mean for the ecosystem if a Google is slowed down, or if it even happens, a little bit reticent about moving forward, and how that changes your thinking too?
Well, I think the FTC's case against Facebook, which we talked about, is potentially a big deal, not only in terms of the fantasized remedy of unwinding those acquisitions, but in what it might do to legal doctrine with respect to these nascent acquisitions and previously cleared deals and so forth. I don't think the government's case, the Justice Department case against Google as it presently stands, is nearly as important. The allegation is that Google has bought agreements with key distributors to make its search engine the default placement. It looks, it's certainly the facts on the face of them raise serious questions. I think they have 87% of the distribution tied up in one form or another. But the legal theory is quite conventional. It's a restriction on the distribution opportunities of rivals. There are potential efficiency justifications. If Google should lose on the facts, there might be some kind of remedy that would be annoying to it. But this case is not going to make new law, and it's not going to, I don't see how it leads to a remedy that in any insignificant way changes Google's size or influence or business model. The state cases against Google, or state's case against Google is, I think, potentially more important because it's on the advertising side. It involves a more complex and maybe difficult to prove set of allegations involving acquisitions and self-preferencing and restrictive agreements and the like. And unless the horse is really out of the barn in terms of the advertising, Google's position in the advertising market, one could imagine some remedies growing out of that that could be important, at least important in the sense of moving advertising dollars around between Google and other platforms. But again, with one caveat I'll mention, I don't see that case as sort of fundamentally changing Google's strategy or business model. The case is styled a little bit of monopolization case. So in principle, you could imagine the plaintiffs, if everything breaks right for them at trial, proving that Google has somehow unlawfully monopolized one of these vertically linked advertising markets, the exchanges or whatever. And that could lead to some divestiture remedies or conduct remedies that could have a more important effect. But even there, I don't think there's any reason to go out and sell your Google stock because of the state's cases.
Thanks for that. Sonja, what's your thoughts on, does this matter in the ecosystem at all, or not much yet?
I mean, obviously Google is one of the #1 companies in the world, right? Great American asset, as well as the leader in search by far. They are a very important acquirer of companies. Several of the firms I've worked for in the past have acquired the companies. And so, as I said before, I think we need to have places where companies can be acquired, and Google is obviously an important one. But I'm not too concerned about Google with the startup ecosystem because, you know, as companies, you used to never want to compete against Microsoft, right? And so companies would just kind of go around and invest in things that Microsoft wasn't doing, and you build some great companies that way. I think the same thing is, I don't think anybody wants to start another search company for a very long time, even though I tried once, but I think they got acquired. But anyway, so I'm not too concerned. I think startup and innovations, it shifts and it changes, and you know this has always been the case where you've had big major companies and people thought they were so solid and no one was ever going to be able to compete with them, and then someone comes up with a brilliant idea, which I would say Google did, you know, several years ago, and you find something different. So I'm not too worried about it.
Got it. Good. Thank you for that. So let's turn to some audience questions. We have several in the queue, and for audience members, please do submit your questions in the Q&A tab. If it's a topic that we've covered already, please don't bother to submit it. But let's start with, here's a question, especially for Commissioner Phillips, but open to everyone. How do you think about anti-competitive behaviors in the big data industry, which is essentially unregulated from a privacy security perspective at the federal level, from the perspective of emphasizing behavior rather than the company itself? Curious about response assertions that the way Google and Facebook and perhaps others behave with data they collect, whether that conduct can be anti-competitive, and obviously not commenting on particular companies, but the space in general.
Sure. No, look, I think that it's up to us, right, to understand how the markets are working. And there are certainly times, right, data can be an important asset. Data are interesting, right, because they're non-rivalrous and there are lots of different ways to get them, but there are ways that combinations of data, right, can create efficiencies, right? You can get more out of having more. Data also, in general, right, tend to devalue over time, right? They become less relevant over time. I don't think there's any particular rule to draw from this, but obviously we have to understand how, you know, a combination of data or the ability to exclude from data, how these dynamics impact, you know, whether it's competition being lost potentially in a merger or the impact of some course of conduct. To me, it's just another aspect of data intensive industries at which we have to look. This isn't entirely new, and it isn't just about big tech, right? There are lots of companies with data. We've dealt with this in the past, right? Requiring companies to do things that address anti-competitive concerns that may arise. That has been historically more of a problem with proprietary data because other data may be more widely available, but it just depends on the dynamics of the particular market.
Mike, can I just add a thought? I completely agree with what Commissioner Phillips said about it's part of the complex factual context that one has to understand. But one thing that is commonly overlooked, it seems to me, in the apologize for the phone in the background here, overlooked in a lot of the public controversy, is that much of what people complain about with respect to data, Amazon using it to feed a smaller company using its platform, or the Google and Facebook using it for targeted advertising. Those, from an economic and from an antitrust perspective, those actions by themselves are unambiguously efficient and welfare enhancing. They are not the stuff of an antitrust violation and probably not the stuff of a public policy transgression. The problems with big data lie elsewhere.
Thank you. Let's turn to another question. Well, this is one I often had when I was a general counsel. Seems to me that legal and regulatory mechanisms and antitrust run at a glacial pace versus the industries they address, especially in the tech industry. How can antitrust enforcement address this issue so that big decisions aren't obsolete by the time they're made? Thoughts on that? It's obviously a loaded question.
Look, to me, I think this impacts, first of all, I think it is true that antitrust litigation, at least, is a slow process. One proposal to deal with this is just to adopt a lot more ex ante rules. There's a theory that we can do this at the FTC. I'm skeptical of it, but certainly in Europe right now, Digital Markets Act, Digital Services Act, these are ex ante rules. intended to get at what are perceived to be problems. The problem with, rules can be good because they give you notice, but they can be overcorrective. And so I think it really depends on what problem you're trying to solve, what the right tool is to solve it, and then what are the costs of solving that rule. And the notion that if we pile more rules on, we will solve all the problems, I'm not sold. I mean, Europe has had abusive dominance for ages. Europe has had, in theory, tougher enforcement, although I'm not sure that's always true. For decades, they've had more regulations. They don't have the competition that many people in America are promising comes with that. To Sonja's point earlier, like VC is a national asset, and it allows us to have goodies that others don't. I will note this, not all antitrust is so slow. Merger enforcement is not as slow. Jamillia was noting earlier, sometimes the process takes a long time. That's true, but you tend to get to like the result of a preliminary injunction hearing in a matter of months, as opposed to like, you start suing IBM in 1969 and you drop the case in the early 80s and you accomplish nothing, which is sort of the famously slow version. So now I've talked too much.
Well, there's another way to solve the problem of proceedings taking too long. And that is to make antitrust law an effective deterrent. Now, unlike Europe, US antitrust law applies to almost all commercial activities that affect the state commerce in the country. What matters about antitrust law is whether we have intelligible principles that businesses can know and can conform to, and that will deter anti-competitive conduct without deterring desirable conduct. And if we have those kinds of principles and suitable remedies, damage remedies, civil fines, whatever they might be, we can have an effective deterrent system, even if the occasional big case that gets litigated takes a couple of years to resolve.
Can I just interpose one point? So Doug is absolutely right, that as a matter of sort of like classical economic role of regulators, clear rules, maybe fines to enforce them, can absolutely deter. However, some of the clear rules that are being proposed these days, I mean, we're only months away from proposals to ban all mergers, right? The other thing you have to think about with clear rules, and I know Doug is not proposing that, but is what is the cost of the rule? I'm not attributing that to you, Doug, but it is something that people are proposing.
I agree.
That's another part of that analysis.
Another way to move things more quickly, and I think we might be headed in that direction. Obviously, there's only so much the regulators can do about litigation and the pace of litigation and what that entails. But if you had, a greater risk tolerance on conduct deals outside of merger litigation, you might bring cases more quickly and get to a decision point more quickly. And adding additional resources, which I know the agencies are both anxious to do, would also enable them to focus on conduct cases. If you think about the agencies, they have to focus on the mergers that come to them, and they have to deal with those on a timeline, and they're put on a clock. So naturally, conduct investigations don't have the resources to move on them. And I suspect, I'm not there right now, but there's also, risk tolerance concerns that slows them down and prevents you from getting to a complaint, which then, of course, would lodge the litigation.
Yeah, I think, along the speed piece and Doug mentioned this, the potential to unwind a deal, as is alleged in the Facebook case, 10 years post, that, to me, I think that was something that industry would look at as very, very challenging to try to assess risk around that. When you think about how all the work that goes into integrating products and investments that are made after a deal. Let's shift gears a little bit. Sonja mentioned at the outset how important privacy is in how she thinks about tech investing. And the question is as follows. Commissioner Phillips mentioned earlier that antitrust may not be the right tool for encouraging powerful firms to protect consumer privacy. And the question is, what regulatory tools would be appropriate, particularly at the FTC? And it could be others, please comment too.
Sure. Look, I think the first answer to that question is, if Congress wants to decide on some rules that govern privacy, we can have a privacy law and we can enforce it. It is funny to me, maybe a little sad. My view is that the FTC packs a bigger punch on privacy than any agency in the world. the effect, the size of the fines, the number of companies, the effect of the injunctive relief, all of these things eclipse any DPA on earth. We do it with like 45 to 60 people, depending on whether you count some of our enforcement staff in addition to our privacy and data protection people. That is a fraction, a small fraction of the number of people you have in Ireland or France, right? Or the United Kingdom. Pick an agency, they're all much larger doing privacy. I do think we can do more with more. Some of that is resources, some of that is law.
Other thoughts? I'd like to ask a broader question to the panel. So as you're all aware, issues of worker welfare, racial and social justice, income inequality, these are top of mind in the national dialogue. They're top of mind for boards of directors, for institutional investors, obviously for advisors to boards, and really for employees at a lot of tech companies. There's been some discussion about the Biden administration using DOJ and Antitrust or FTC and its regulatory authority to help advance issues of racial and social justice. How likely is that in the panel's view? And what would be the tools to do that, to get into social issues away from kind of the core legal theories that we talked about?
Well, I think social issues are really important. As we've just seen in the California law that requires women board members, right? The venture industry in terms of percentage of women hasn't changed in 30 years. And there are very few Black people in the venture industry or in tech industry. So it would seem that given the success of the law in California about putting more women on boards, that regulations actually and laws do actually work. And it would seem that over time, over the last 30 years where I've been a venture capitalist, they haven't done it themselves. And so I actually think regulation is a good thing when it comes to minorities, people of color, women, because it will cause change. And, if you look at the Perkins Fund portfolio, we have 12% Black women in our portfolio. The industry average is 0.26% funding, right? Something really wrong with that. Same with women. We have 50% women. The industry average of women getting funded is less than 10%. So something has to give, and we've given it, I think, enough time. And I would be very open to having regulations to make the power positions equal to the population dynamics.
Let me just add, with new legislation or new regulations, federal government can do a great deal to advance some of those important interests of equality. But without new regulation or new legislation, the antitrust laws can have very little impact on that. If someone brought an antitrust case and went into court and said, Your Honor, this is a big guy who's very wealthy, we want to break him up because the little guys are getting hurt, he'd get thrown out pretty quickly. These factors are not material to an antitrust analysis or antitrust case. I do think there may be some conscious or unconscious influence on case selection, where enforcers, state or federal, might look at two opportunities to invest resources and say, well, that one has a big payoff beyond the narrow antitrust concerns. Let's focus there. But beyond that, I don't see antitrust as being the tool for these other objectives.
Great. So we have 2 minutes left, and let's finish on the last question from the audience here. Looking for a reaction to the fact that President Biden has recently named 2 proactive antitrust advocates, one perhaps to the FTC and one to the White House. Would folks like to comment on what these appointments may mean for the future?
Since I'm the academic one here, let me speculate. Commissioner Chopra, now on the commission, I think he's still there, I'm not sure, but certainly was until recently, to oversimplify, is a populist, but he's leading the commission. Lena Khan is a prominent populist, very bright, very engaging young lawyer. You could look at her as replacing him. That still leaves a vacancy in the commission, and it still leaves, we don't have a candidate yet for the head of the Antitrust Division, so it's not clear whether the nominees for those decisive positions, which will change the balance from what it was previously, are going to go in the populist direction, or what I would call the mainstream progressive. If the latter, then the appointments, I don't think indicate a significant change in terms of populist influence. Tim Wu's appointment to the White House position actually makes a lot of sense. He's a big picture kind of guy, very creative, very bright, and he might do some very interesting things in terms of helping spread competition values and competition policies throughout the other agencies that have often been very resistant to that while they protected their individual constituents. But I don't know, but I would doubt, given the tradition, that he would have much case-by-case influence on the activities of the agencies. That's just, by the way, outsider's conjecture. I have no inside information.
No, I appreciate that perspective. Well, this is terrific. Doug, does anybody want to add anything, or we can wrap up here? All good? Great. It's 2 o'clock. I want to thank our panelists for taking the time to be with us. Your schedules are incredibly busy, and you've been very generous with your time and your insights. And so thank you on behalf of Stanford Law School and the Rock Center. And thanks to the hundreds of folks who decided to spend an afternoon with us and learn more from all of your expertise. Appreciate everybody's engagement and the questions.
Thank you.
And I hope you all have a great day. Thanks for joining us.
Thanks so much, Mike, and thanks to
Thanks
all of
so
you.
much. Nice to see everybody.
Bye-bye.
Bye.